False imprisonment is usually the third intentional tort taught in a 1L torts class. However, it is the first of the intentional torts affecting one's person that does not, per se, involve harmful or offensive contact to one's person. Instead, false imprisonment involves the unconsented confinement of one's person inside a bounded space by another. As with all things legal, there are always caveats and qualifications to seemingly simple definitions. That is what this video will focus on. Welcome to Roman Matter. This lesson will explore the intentional tort of false imprisonment. We will cover how the tort is defined, examine its elements, and go over a few examples. A word of caution, this course is intended to answer academic questions only. These materials are intended to reinforce your legal education or to satisfy the curious layperson, not legal advice. And with that, let's get to it. So what is false imprisonment? The Restatement Second of Torts, Section 35, subsection 1, describes the circumstances under which an individual can be held liable for false imprisonment. Subsection 1 provides a three-part definition. It states that, quote, an actor is subject to liability to another for false imprisonment if A. He acts intending to confine the other or a third person within the boundaries fixed by the actor, and B. His act directly or indirectly results in such a confinement of the other, and C. The other is conscious of the confinement or is harmed by it. Subsection 2 continues, stating that, quote, an act which is not done with the intention stated in subsection 1a does not make the actor liable to the other for a merely transitory or otherwise harmless confinement, although the act involves an unreasonable risk of imposing it, and therefore would be negligent or reckless if the risk threatened bodily harm. Subsection 2 exists to excuse short and accidental confinement that does not result in bodily harm to the person confined. As with the prior lessons, we can mold the restatement's lengthy definition together and state it more concisely for the purposes of a law school exam. We can say that, to make a prima facie case for false imprisonment, the plaintiff must show the defendant acted intentionally to confine the plaintiff to a physically bounded area, that the plaintiff was confined, and that the plaintiff was either aware of the confinement or harmed by it. There is a bit to unpack here, so let's dig into the critical pieces composing the definition for false imprisonment. Intent. This requirement is integral to all intentional torts. Simply put, the tortfeasor must have acted with intent. The Restatement Second of Torts, Section 1, states that, quote, a person acts with the intent to produce a consequence if A. the person acts with the purpose of producing that consequence, or B. the person acts knowing that the consequence is substantially certain to result. In either instance, whether the actor acts with the purpose to confine another or commits an act substantially certain to result in another's confinement, the intent element will be satisfied. What is confinement? Black's Law defines confinement as, quote, the act of imprisoning or restraining someone, and as the state of being imprisoned or restrained. The Restatement Second of Torts, Section 36, describes the circumstances that will make an actor liable for confining another. Its provisions state that in order to make the actor liable for false imprisonment, the other's confinement within the boundaries fixed by the actor must be complete, and that the confinement is complete although there is a reasonable means of escape unless the other knows of it. This is to say, a person's confinement to a bounded area may be complete even if a reasonable means of escape does, in fact, exist. That will be the case if the confined person is unaware a reasonable means of escape exists, or that means of escape is either too dangerous or harmful to their sense of personal dignity. Section 36, Comment A clarifies that a reasonable means of escape cannot subject the confined person to, quote, circumstances such as to make its use offensive to a reasonable sense of decency or personal dignity, unquote. Think of a person who showered at the gym locker room and had their clothes stolen. That person can certainly leave the locker room, but they can't do so without appearing naked in public. Such an individual has been falsely imprisoned by the actor who stole their clothes. Section 36, subsection 3 continues, stating that, quote, the actor does not become liable for false imprisonment by intentionally preventing another from going in a particular direction in which he has a right or privilege to go. For example, think of an actor standing in the way or blocking another on a public sidewalk. Such an act is certainly inconvenient, but this act alone will not make the actor liable to the other for false imprisonment, even though that other will have to change course, go around, or find a different route. How is confinement achieved? Confinement can be achieved in an infinite number of ways, but broadly we can describe the most common ways that this is achieved by three means. Confinement can be achieved by physical force, by threats of physical force, and by asserting apparent legal authority. Let's take a closer look at each of these circumstances. Confinement by physical force. The Restatement Second of Torts, Section 39, defines confinement by physical force. It states that, quote, the confinement may be achieved by overpowering physical force or by submission to physical force. This is rather straightforward. Think of the actor who physically overpowers another to place them in a room that is then locked with the other inside. Or think of the actor who blocks another's exit from a store by placing their car in front of the only exit. Confinement by threats of physical force. The Restatement Second of Torts, Section 40, defines confinement by threats of physical force. It describes the circumstances under which this can occur, stating that, quote, the confinement may be achieved by submission to a threat to apply physical force to the other's person immediately upon the other's going or attempting to go beyond the area in which the actor intends to confine him, unquote. This builds upon the prior concept. However, what is key is the immediacy of the threat. The force threatened must be threatened to occur immediately to the confined other's person should they attempt to leave the area of confinement. A threat of future physical force is insufficient. Confinement by asserted legal authority. The Restatement Second of Torts, Section 41, defines confinement by asserted legal authority. It describes the circumstances under which this can occur, stating that, quote, the confinement may be by taking a person into custody under an asserted legal authority, and 2, the custody is complete if the person against whom and in whose presence the authority is asserted believes it to be valid or is in doubt as to its authority and submits to it anyway. The illustrations given in the restatement reference civilians posing as police officers and using the authority of law enforcement to falsely imprison others. In law school, however, this concept is usually tested in exams in conjunction with the shopkeeper's privilege. The shopkeeper's privilege permits shopkeepers or their employees to physically detain suspected shoplifters for only so long as is necessary to recover the store's merchandise. Once the store's chattels have been recovered, the shopkeeper is obligated to turn the shoplifter over to the police or to release them entirely. Holding the shoplifter for longer than necessary can result in the shopkeeper exceeding this privilege, and she may find herself liable to the shoplifter for false imprisonment. Physically bounded area. Of course, the plaintiff must be confined within a physical space of some sort. Usually this will be a room or building, but not always. A plaintiff can be confined to a parking lot or a public park to the same extent that he is bound within a defendant's room of his choosing. But false imprisonment can also occur in instances where a plaintiff is confined to a boat, aircraft, or other vehicle. What matters is that the plaintiff is confined to a bounded physical space of the defendant's choosing. Awareness of the confinement. Confinement is necessary but not sufficient to prove false imprisonment. Regardless of the means of confinement, the plaintiff must also be aware of the confinement imposed by the defendant. Just as with assault, the plaintiff must know of the Torts Act. Being informed after the fact is insufficient to support liability. Unaware of or unable to use any possible exit from the bounded area. The plaintiff must lack knowledge of a reasonable exit from the bounded area, or, if the plaintiff is aware of an exit, that exit must be unreasonable to utilize. What would make the exit unreasonable to use is a context-specific problem. Usually the exit is too dangerous to utilize or subjects the plaintiff to embarrassment. Again, think of someone in a gym locker room. He takes a shower after a workout, and while cleaning up, a troublemaker takes his clothes. After leaving the shower, and despite the door to the locker room being unlocked, our new gym-goer is unable to leave and thus has been falsely imprisoned. Now let's take a look at a few examples of false imprisonment to see the concept in action. Pete and Dan worked together at a law firm. Pete was the new associate and Dan his supervising attorney. Dan was behind on briefs necessary to move forward on another matter, so he told Pete that he was going to do the heavy lifting on the legal research needed to get it done. To motivate Pete, Dan told him that he wasn't leaving the office until the research got done. Pete just smiled and laughed a nervous laugh, but Dan wasn't kidding though. He locked Pete in Pete's own office to ensure that he didn't leave until the briefs were finished. Pete had no way of leaving the office. The door was locked, Dan had the key, and the windows on the 9th floor weren't of the sort that he could open. Besides, Pete was on the 9th floor. Even if the windows could open, it would be too dangerous to try to exit that way. In this example, Dan clearly committed the intentional tort of false imprisonment. It's also important to understand that Dan didn't have to lock Pete in the office to actually commit false imprisonment. Had Dan stood in the doorway of Pete's office such that Pete felt he could not leave, then Dan would have committed this tort as well. It does not matter how long he stood there either, only that Pete felt that when he did, he could not leave. A few weeks before our prior example, Pete was working late as first-year associates often do when he left the office and headed towards his car in the parking garage. Derek, the new security guard tasked with patrolling the garage and keeping it safe, was also eager to prove himself to his boss. Pete took the elevator from his office on the 9th floor down to the garage to drive home. He didn't realize it, but Derek, in his eagerness, had already blocked all the exits. Not just the sole exit his car could safely drive out of, but all the doors he could walk out of as well. Pete could have jumped from the 3rd floor of the garage, but doing so would likely result in his injury. So poor Pete had to spend the night sleeping in the back of his car. Under these facts, Derek did not falsely imprison Pete. Derek lacked the intent to do so, even though for all practical purposes, Pete was confined to a physically bounded area he could not reasonably escape from. What matters here is that Derek lacked the intent to do so. These facts don't tell us that Derek intended to falsely imprison anyone. It was late. He thought everyone had left for the day, and he wanted to make sure the garage was locked up. Further, this unintended confinement did not threaten bodily harm to Pete. Now, had Pete's firm been located in Minnesota, and this scenario taken place in January, Pete could argue that Derek's actions threatened bodily harm. Pete would have been very cold in his car, to the extent that he may have suffered hypothermia, and therefore experienced physical harm to his person. Okay, so let's sum it up. An actor falsely imprisons another if he confines the other to a physically bounded space. The other is aware of the confinement, and there is either no reasonable means of escape available, or the confined other would be physically harmed in the confinement. So long as these elements are satisfied, then liability for false imprisonment will attach to the actor. That's it for this lesson. If you found it helpful, give the video a like and subscribe to the channel. Leave some comments below and check back often for more content. As always, thank you for visiting Roman Manor and have a lovely day.